Welcome. Today's presentation is on recently published frequently asked questions pertinent to repatriation of export proceeds into Sri Lanka. This is related to rules number 5 of 2021 published in the recent Gazette. What is the scope of application of these repatriation rules? These are applicable to all export proceeds. All exporters of goods and receives services including professional, vocational, occupational and business services. Proceeds of exports bills purchases or bills discounting facilities, margin and commission income, FC earnings such as agency commissions. Are the workers' remittances by Sri Lankans working abroad subject to these rules? These rules do not apply to workers' remittances. What is the application of these rules for export proceeds already received prior to 28 October 2021 and not converted to up to date, where 30 days have not lapsed and remain within 180 days from the date of export? Export proceeds already repatriated to the country up to this 28th October 2021 are subjected to conversion requirements. Is there a minimum residual amount that needs to be converted as per the rules given? No. Minimum conversion requirement is not given. Required to convert the entire residual balance of the export proceeds received in a particular calendar month into LKR after meeting the authorized payments. Can the loan repayments and travel purposes be recognized as allowed for 1 month commitments in terms of these rules? No. It must also be noted that the 180 days time span is not applicable when honoring the 1 month commitments, and banks are required to convert the proceeds that have not been utilized during the 1 month. Can export proceeds be remitted to another bank for conversion? No. Can the bank accommodate any customer requests for building up FC balances over a period for term loans or capital expenditure for such facilities? Accumulation is not permitted. What if the customer instructions are not received by the 7th of next month for conversion by the bank in order to apply the requirement? Banks are required to convert export proceeds by the due date. How should the bank deal with the export proceeds which may be received after 180 days? Non-repatriation is required to be reported to CBSL. Can the individual customers transfer FC within own accounts of different banks where such proceeds are originated from service exports? That is not permitted. Can local suppliers be paid under the authorized payments in terms of these rules? Payment in FC to the local suppliers in the following instances will be recognized as authorized payments: payment for imported raw materials of a local supplier and payment for the repayment of a FC loan obtained by a local supplier for the supply of goods to the exporter. Are the banks allowed to grant up to 100% of the export value for export-related accommodations? Banks are required to access the real necessity of the customers for such accommodations in accordance with their past track record, market practices, and the prevalent situation of the economy. Banks should not extend accommodation in FC evading the requirements of these rules. Can freight forwarders, shipping and airline agents licensed by the Director General of Merchant Shipping or Director General of Civil Aviation Authority, port terminal operators, warehouse and logistics service providers, and other related service providers be paid under the authorized payment in terms of these rules? Exporters of goods may make payments in FC for the services provided by these freight forwarders and other parties. Can local agents make payment to local service providers in foreign currency out of the FC collected from non-resident for service provided by such local service providers? This is permitted. Such foreign currency received by local service provider shall be subject to the requirements of these rules. Thanks for watching.